Senator Hagerty.
Thank you, Chairman Van Hollen, and welcome to the two chairmen today. Chairman Gensler, I want to start with you. You may recall that last September in a banking committee meeting, you and I discussed the SEC's tortured, in my view, legally baseless interpretation of Section 913 of Dodd-Frank. And you've relied on Section 913 to justify, I think, some of the most controversial rulemakings you've done, notably the private funds rule, the predictive data analytics rule. Just last week, the Fifth Circuit struck down the private funds rule. It acknowledged what I think many market participants had warned about, other commissioners had warned about, members of the Senate had warned about. Yet you're back now asking for $2.6 billion for fiscal year 25. And it concerns me that SEC staff resources are being wastefully deployed on rulemakings that wind up not affecting the markets as you would hope. In fact, they're way outside of your remit. I'd like to ask you, Mr. Chairman, how many SEC employees, you mentioned 70% of your budget is people. I'd like to understand what percentage of the staff have been tied up working on the private funds rule, the predictive data analytics rule, the climate disclosure rule, the dealer rule, the safeguarding rule, the stock buyback rule, the best execution rule, and the order competition rule. Can you tell me how many of your staff resources have been dedicated to these more partisan, baseless, in my view, interpretations of the law?
I thank you, and I do remember the conversation. If I might say, what we did in that rule, I think, was to help investors in private funds get quarterly statements on their fees, performance, and any side deals with other investors. And it was based upon, as you rightly said, a new provision in Dodd-Frank from 12 or 14 years ago from Dodd-Frank. We thought and believed that it was within the law. The Fifth Circuit
I think you were warned that it wasn't.
Found otherwise, and we respect, we do things within the law and how courts interpret it. On your general question about staffing, I think it's less than probably 5% of our 5,000 people at any given time that are working on rulemaking. It's people in our chief economist's office, people in our office general counsel, people in the various policy divisions, of course, the commissioners themselves. But on the order of magnitude, it could be 200, it could be 300 people in the whole agency that in part are working on it. They're not full-time. The economists are working on other things as well, of course.
Well, let's go back to how you prioritize resources, because instead of staffing resources outside of the remit, which I think that full litany of rules that I just read are outside of your boundaries and outside of your remit, you're also not prioritizing staff and you're not prioritizing rulemaking for areas that desperately need it. And here I'm talking about setting in place a constructive set of rules of the road for the crypto industry. This is an innovative industry. It's an industry that the United States should be leading on, yet other jurisdictions in other countries are setting up rules for their ecosystems. Yet what happens here with the SEC and with the CFTC is constant roadblocks and a lack of certainty. And what's happening is that this innovative industry is finding itself increasingly pushed offshore. I don't think that's the result that we want to have here in America. And I certainly think a far better allocation of resources, rather than putting it against the private funds rule or predictive data analytics rule, would be to focus on setting in place rules of the road for innovative markets like this. I want to take, for example, the years-long process that it took to approve Bitcoin's ETF. And that only happened recently. And it happened in the wake of a court finding that your grounds for disapproval was warrantless. And I'm just very puzzled that in light of the most recent court ruling, why we haven't fully approved the issuance of Ether ETFs. Chairman Ben, I'm going to turn to you. Is Ether a commodity? A yes or no answer will do.
Yes.
Chairman Gensler, same question. Is Ether a commodity?
Senator, we actually, as an agency, did approve Ethereum exchange-traded
Only
products.
partially. It's not, the approval is not complete.
Well, we address ourselves to the filings in front of us, and we approved it. And
So you're saying that all Ether applications have been approved by the SEC that are pending
the
right now?
Ethereum exchange-traded product of filings that were in front of us from stock exchanges, I think there were 8 or 9 of them, were all jointly approved. Individual issuers still are working through the registration process that's working smoothly, and I would envision sometime over the course of this summer, those are just disclosure
That's great
documents.
news. If you're committing to me that those applications will be approved by the end of the summer, I appreciate that. We've got to get this market.
Yeah, we've already approved, and if I can say just a little bit further, the Ethereum exchange-traded product, we actually last summer had already, based upon a well-regulated market, the Chicago Mercantile Exchange has Ethereum futures contracts that are 3 or 4 years old already. Based upon that well-regulated market, even last summer we had, there were Ethereum exchange-traded products, it was called ETFs, based upon those Ethereum futures last summer. That's already happened.
Well, I take it from your answer then that the applications that are still pending for Ether, this would be very helpful to the marketplace to get this clarified, that you're ready to approve those. You'll get those done this summer, is that what you said?
Again, that's done at a staff level, but it's just disclosure and registration, and those registration statements have to have the proper disclosures and go through before they go what's called effective.
Well, the
but we've
Bitcoin
already,
ETF
as a
approval
commission,
was
already
important.
approved the
Ether needs to be
ETP.
approved as well, completely. I'm going to move quickly on to another question here that I've got, and that has to do with, and Chairman Von Hollen brought this up, the consolidated audit trail data. And I think this is a concern, Mr. Chairman, that a number of us feel. It's an extensive amount of data, billions of dollars worth of equity and option trading data, and it does have personally identifiable information on investors associated with that, as you mentioned, Mr. Chairman. But I think all of us are concerned. If we look at other agencies, for example, the IRS, the IRS has had a very terrible track record of being able to maintain and protect individual taxpayers' data. There's a person sitting in jail right now who disclosed thousands of taxpayer returns in their data just so they could go after political enemies. You think about the FISA context. We found out that in 2021, the number was 278,000 times in 2021. There was unauthorized access of Americans' personal data, including political figures. And so there is a deep concern there about this type of data availability, what's being done to protect it. You mentioned at any time you've got 1,500 to 2,000 investigations underway, presumably relying on this data. What are you doing to protect it, and what law requires you to protect it and to penalize anybody that might disclose it?
It's a very important matter to us. First, only a limited number of people at the SEC even have access to look at.
Can you give us the numbers, Mr. Chair, to give a sense for that?
It's less than 3 or 4% of the agency. We can come back to you and give you, but it's in that 100 to 200 range. So it's not even the whole 1,300 people in enforcement, to give you a sense. It's a much narrower group of people, and that's a really, they all go through particular training and so forth of how to access it.
How did they get permission to access it?
With respect, so we have 7 minutes allocated for colleagues. We're about 1 minute 45 seconds over here in terms of exchange. If you wouldn't mind just a quick answer, because I just want to make sure we get to other members. I don't know if, and we're going to have another round. Okay. I have 7 minutes so people could have plenty of time. Now we're. Okay.
And I'm also willing, Senator, to meet with you later today or tomorrow, or to get on the phone and chat this through with you, or any other matter with you.
Yeah. No,
we can come back to it on the second round too. I just want to make sure. So let me pick up, if I could, Chairman Gensler. Senator Hagerty raised the issue of crypto assets, cryptocurrency. Obviously, this is an area where Chairman Benham has been involved as well, and we all are very aware of the fact that there's a big debate going on Capitol Hill right now regarding whether these things are fish or fowl and which agency should have jurisdiction. But I would hope that we would all be able to agree on a couple things, which is that we want to protect consumers and the public, number one. And number two, however we move forward, we deal with the anti-money laundering equivalent part of this, making sure that these assets cannot be used for nefarious purposes. So again, our House subcommittee counterpart included a provision, Chairman Gensler, regarding SEC crypto regulation, and specifically it reads, none of the funds made available by this act may be used to carry out an enforcement action related to a digital asset transaction, except for enforcement actions related to fraud or market manipulation, unless, and it goes out and sets out some conditions. Could you speak to what the consequences would be with respect to the goal of protecting consumers and the public if this were adopted?
It would be seriously undercut our efforts. While not all crypto or crypto securities, some are under Chair Benham's jurisdiction, those that are have an obligation to disclose to the public. It's called a registration to disclose to the public full, fair, and complete information. We'd lose that. Secondly, intermediaries, so-called exchanges, broker-dealers, and the like, register, and then the public gets protection. For instance, a really key protection is that your funds are segregated and protected. And so our securities laws are not solely about fraud and manipulation. Stamping out fraud and manipulation is really important, but it's also about if you register, in this case, a crypto security token, you have to then give disclosure so the investing public gets the benefit of that. If you register a crypto broker or crypto exchange, you get the benefit of things like segregation. You get the benefit of a rule book on the exchange, like we have on, let's say, the New York Stock Exchange. There's a lot of benefits, but it would also undercut ongoing current cases that we have in front of courts right now. And we've been very successful in a number of these cases where, at least on the law, on motions to dismiss and so forth, the judges have found we've got the appropriate reading of the law, and then they'll move on to the fact part of the cases.
So just to be clear on that last point, this would interfere directly in ongoing cases?
It would interfere directly on ongoing cases that we have in front of various various district courts.
Thank you. So, Chairman Benham, I mentioned the importance of making sure that these assets, currencies, cannot be used for nefarious purposes, and the need to apply the equivalent of the anti-money laundering standards to these assets, regardless of how we decide to treat them. Would you agree with that? And what measures should we use? Should we just simply apply existing AML provisions to these currencies?
Senator, thanks for the question. You know, from a CFTC perspective, and as I've said publicly for many years now, it's a legal authority issue. We, to Chair Gensler's point in the earlier question, have anti-fraud and anti-manipulation authority for digital commodity assets. So we've been quite successful over the past 10 years, really, in bringing enforcement cases. But the weakness that we have, or the shortcoming, is that we have to rely on folks coming to us providing tips and complaints. We don't have those traditional regulatory tools, registration, custody, surveillance, oversight, that have really made American capital markets and derivatives markets so strong. As it relates to AML KYC, again, it's a legal authority issue. If Congress were to move on some authority for the CFTC, certainly that would be a key component of this, given what we've seen and experienced in this digital asset space around AML and KYC. I don't think we need to stray too far from existing law. A lot of AML KYC enforcement is conducted through the Treasury Department. We work very closely with FinCEN on certain authorities we have, but it is limited in scope. But I would think, you know, the current AML KYC structure at a bare minimum is adequate. I do think the technology would require some rethinking of how we need to consider both anti-money laundering and know your customer.
Thank you. Chairman Gensler,
Could I just
comment
say,
on that?
one of the real challenges is that these crypto tokens are transferable outside of the traditional financial sector on what's called permissionless ledgers. And so one of the real challenges is it's not as easy to apply the anti-money laundering laws. So, for instance, Bitcoin is the token of choice by ransomware attacks. I mean, that's it, pay us in Bitcoin. And you can imagine there's a whole cottage industry in, Eastern Europe preying upon U.S. companies